on the documents
of somebody else's.
Yeah, but I patiently remember what I said. I said, this lady, Pinky, telling him, can't testify on the affidavit of a house.
Yes.
That's what I said.
Yes.
Now this witness, they can have here. He says, I am the one who composed this document.
Yes.
They say you can't testify on that because it's a document of Vodacom.
Yes.
But his evidence, he compiled this document together with.
So let's spend Saturday and detox from the Mzansi trial because you already know this past week has been a lot. So this new case, well, not really new, but this new suspect that has been charged actually caught my attention because she was extradited from the United States, okay? Dragged back to South Africa by the Hawks and Interpol and the Dondonis, okay? And they issued out a red notice, which means she is a wanted fugitive worldwide. Now take a look at this. She looks nothing like a fugitive. If at all anything, this takes me back to the days of Dr. Nandipa Magudumana and who? Thabo Bester, and how that all went down. So these images caught my attention and, I wanted to get to know more about this case. So as you already know, here is a summary of what exactly is going on. So her name is Magashule'S. And who is she? She is Ace Magashule'S former PA. And she has been extradited from the United States to face charges, okay? Several charges, that is, in the 255 million asbestos trial. And her bail hearing was being held by who? Magistrate Estelle DeLange. Now, let me tell you something about this woman. She is no stranger to this channel, okay? This magistrate also presided over the bail hearing, if I'm not mistaken, but correct me in the comment section down below, of who? Nandipa Magudumana. So, going to other courtrooms, virtually that is, and just listening to other judges and magistrates and then realizing, wait a minute, why is it chaos only in the Mzansi trial? Like this woman, this case went on from Monday, was adjourned, I think, till Tuesday. From Tuesday, it was adjourned till Thursday. And then finally, the bail decision was granted. Things are moving. Meanwhile, in the Mzansi trial, we're just still trying to understand cell phone towers and why, if it is Colonel Stain, Mr. Stain, that is, added numbers to the download document, yes or no, we still don't know. Will we ever find out? That is still a developing story. So here's a brief update on what's going on with Ace Magashule'S former PA's bail application. I'm going to let you watch the proceedings, but let me tell you something. I learned a lot in that case, how the judge reached her decision, how the state was not successful in their quest to, oppose the application. And guess what? Magashule'S also has what? Female legal representation. And her name is Loisa Makapela. She also, in my opinion, I think she did a phenomenal job. So this is a new case that I'm introducing to the channel that I'll be featuring here and there rather. And I thought, you know what? Saturday is a good time to introduce a new case to you guys so that, we digest, digress, and find out what really happens in other courtrooms and if justice is actually served. So her story is that she was Ace Magashule'S former PA. She went to, and this is all the information from her responding affidavit, okay? So she went to the United States of America, was in some university in Baltimore, where she was arrested in April, okay, for her extradition order. Okay. But they kept her in custody from April all the way until she was flown right back here to South Africa. Now, why do I bring up the word extradition? Look how I'm full transparency. I'm going to say I assumed that the state had an airtight case, because if America granted the extradition, because we see over there in Eswatini, just right here, right around the corner, Eswatini is still holding on strong to those Ndimande brothers, okay, aka in the AKA and Tibbs murder trial. They're still holding on strong to those boys. But now that I assumed, and now we know We just got to follow what? We've got to follow the bouncing ball, and we've got to do it without emotion and always innocent until proven guilty. So what exactly happened with her? I assumed that because the American courts granted her extradition, okay, so that she could come and face the charges of her alleged crimes here in South Africa, that there's a level of guilt. But then we hear the judge go through the proceedings or how she reached the decision regarding the bail. And that's where I paused and took a moment to say, oh, okay, I see what you're saying. So the state's case is not exactly airtight. And some of the things that we found out is that, hey, she has a son who's 14 years old living with his Nigerian father in Nigeria. And we already know there's been a lot of hoo-ha about Nigeria, this and that. So the state was opposing bail, saying, hey, her child is in Nigeria. Chances of her disappearing to Nigeria, pretty high. Something else that we also found out is that she was studying in the United States under a bursary. How did she qualify for the bursary? So, how did she qualify for a bursary that is meant for the disadvantaged individuals, but she wasn't disadvantaged? And she says that she can only pay bail of $2,500. 2,500 rands, not dollars, rands. I mean, this is a very, very interesting case. I would like to break it down for you. But let me let you guys watch how court goes, okay? In the magistrate's office and the magistrate's court over there, we're in Bloemfontein. This is definitely a developing story. And I want to also add a disclaimer. This is, of course, a recent case. One disclaimer, okay? That even though she was extradited from the United States of America after being in custody for 4 months, okay, in an American prison, and then spending about, I think, a week in South African prison, she is obviously assumed innocent. And this is not a judgment on her, but this story is being brought to you so that we can follow this case, as it is definitely a developing story. So everything in this video is obviously still allegations, as the merits of the case have not yet gone through court. Okay, so let's go ahead and listen to the bail application judgment by the Honorable Estelle Dilang. I'd like you to pay attention, of course, to the professionalism, the court decorum that is currently being presented in this magistrate court, a lower court than the high court that Judge Ratha is presiding over. But you know what? There's no hand throwing. She has no facial expressions. She's tech savvy. Okay, I think she'll be able to understand between the PDF, Excel spreadsheet, and Doni, CD, USB. She seems to be quite a tech savvy magistrate over there. But you know what? Let's jump straight into it, because this is definitely interesting. Thanks for watching. Remember to like, comment, and subscribe. Go ahead and like right now, and let's get into this magistrate court.
I'm not going to waste any further time. I'm going to proceed with judgment. Thank you. The applicant, Ms. Charlotta, is applying for bail. She was represented by Advocate Macapela. The state is represented by Advocate De Mason. The applicant is charged with fraud and corruption resulting under Schedule 5 of the Criminal Procedure Act. The state and the defence both agreed on the schedule, and we proceeded with it as a Schedule 5 offence. The law states that the applicant must be given a reasonable opportunity to satisfy the court that the interest of justice permits her release on bail, and the onus of proof is on her to prove it to the court on a balance of probability. She applied for bail by handing in an affidavit, and the state requested an opportunity to prepare their papers until the next day, and the defence inquired from the court if they will get an opportunity to reply to the affidavit by the state. I must just also now further add that it is unusual for a court in a bail application to receive replying affidavits. It's normally just the applications, and it must be comprehensively done to cover all aspects. But I do have a discretion, and I decided to allow that, and I will now just give a short, brief reason for me allowing that under these particular circumstances. I don't normally do that. When the application started, the defence handed to me the indictment, which already indicated to me that the matter that she's facing will be transferred to the High Court immediately upon conclusion of the bail application. The court is also fully aware of the fact that should bail be refused by the court today, and there are new facts that arise to bail on new facts, and the matter is already in the High Court, I will be precluded from hearing the bail on new facts. So it is very important for us to air each and every aspect in this bail application now, so that there is no reason why it should come back, or an attempt made to come back to the school to deal with an application on new facts. So that is why I allowed it. And the second reason is because the state did not have the affidavit ready and prepared. So it was not available to the defense. They couldn't peruse it beforehand to amend their application in accordance with that. And it is only fair that the applicant be given a reasonable opportunity to satisfy the court that it's in the interest of justice to be released on bail. And she can only do that if she also has access to the affidavit by the state. So that is the two reasons why I decided that I'm going to deviate from the normal procedure. The state returned the next day and handed an affidavit into court, reading it into the record, indicating that they are opposed to bail, and mentioned that the main reason for them being opposed to bail is the fact that they regard the applicant as a flight risk, and that there is a likelihood that she will not stand trial. And they listed various reasons in the affidavit for that conclusion that they made. At the end of that, the defense did not have a replying affidavit ready, and they indicated to the court that they need time from Tuesday until Thursday to draft the replying affidavit. The defense did express their dissatisfaction to the court for not allowing them to present their submissions orally, but it is important to note that a replying affidavit cannot be presented by the defense by addressing the court from the bar. It can only be done by an applicant deposing to an affidavit or by otherwise testifying under oath. However, the matter was postponed until today, and the affidavit was handed in today. It was a comprehensive affidavit, and I want to also just say to the defense, I appreciate the time that I put into that to have it ready for us today so that we can proceed with this application. The state and the defense both presented their arguments today. There were heads of argument, and they also elaborated on what was contained in their heads of argument. Now, if I get to the application itself, the applicant placed her personal circumstances before the court on record. She also indicated that she does not have family members, that she has family members in Bloemfontein in this area, and that she will be living with them if she is released on bail. She was extradited from the United States, where she was studying at the time, and she was brought back to South Africa. She was in the United States unemployed, and she used her bursary money to, not the bursary money, but the funds that that university provided to her to study with, to also support herself at the time, because her bursary from South Africa had been cancelled. She is still unemployed and can only raise an amount of 2,500 rand bail, but if need be, she would be able to raise more. She explained that her travel documents and her passport remained behind in the United States when she was brought to South Africa, and emergency travel documents were issued to get her to South Africa after she was the extradition proceedings was successful. She had no previous convictions, pending criminal cases against her. She also intends to plead not guilty to the charges against her. She's not a danger to the public or any individual. She will not attempt to evade trial. The State Advocate Denison read the investigating officer's affidavit into the record. It is also quite a lengthy affidavit, and that already is a clear indication against the applicant in order to charge her, because they are going to proceed against her in the High Court. The state opposed the bail on allegations that she's a flight risk and there's a likelihood that she will not stand trial. And this is based on the actions of the accused, who had to be extradited. And she opposed the extradition proceedings. She had attorneys present and advocates representing her. She also filed papers and with the Constitutional Court requesting direct access to them. This was refused. And the state basically claims that all the legal avenues that she followed to try and prevent the process being followed against her was to waste time. The bulk of the affidavit, the rest of the information, contains information regarding the charges against her, the extradition proceedings, and so forth. I'm not going to repeat any of that because we are all fully aware what is contained in it. It was also made available to all parties and to the media, so they also have access to that. The defense responded to the state's affidavit with an equally lengthy response, indicating different or giving different explanations for all the allegations made by the state in the affidavit, dealing with a point-by-point basis. She also deals extensively in her affidavit with all the issues, also including the fact that there's an allegation that she's a flight risk and that she will not attempt to evade her trial. And in an affidavit, she also explained her presence in the United States and why she was there and where she was at all times while the investigation in this Magashule'S case was busy going on. This was the applicant's case. I'm not mentioning everything just to save time, but this is the most important aspects which I am taking into account in this decision. The state and the defense then also just addressed me, and I must mention that Section 60, subsection 4, contains certain grounds that the court should take into account in deciding whether it is in the interest of justice to grant bail to the applicant or not. Now, the first ground is if there's a likelihood that the applicant, if she is released on bail, will endanger the safety of the public or a particular person. That is not a ground that the state relies on, but they are relying on the second ground mentioned here under subsection B, which is a likelihood that if she is released on bail, that she will attempt to evade her trial. And that is, the others are also not applicable because it's not, the state does not have any fear that she will commit any of those. Now, in considering whether the ground in subsection 4B has been established, the court may take into account various factors, and it's also listed there. The first factor that is listed is the emotional and family, community, or occupational ties of the accused in the place where she is supposed to be tried. Now, she's going to be tried in Bloemfontein. She is a South African citizen, although she's studying in the United States. She was also there for about 4 years. She has family and she's got friends in South Africa. Although she was away for 4 years, it doesn't mean that they do not remain her family and her friends in this country. The assets held by the accused and the places where the assets are situated is she owns fixed property in grasslands in Bloemfontein, and she is renting that property out. The third factor is the means and travel documents held by the accused, which may enable her, they refer here to the accused, the applicant, which may enable her to leave the country. At this stage, she has no travel documents in her possession. It was left behind in the United States. Fourthly, that's under subsection B, the extent, if any, to which the accused can afford to forfeit the amount of bail which may be set. At this stage, her real financial means is not known to the court. She indicated that she's unemployed and that she will stay with family members. The question whether the extradition of the accused would readily be affected if she attempts or flees across the borders of the Republic, it is not possible to make any remarks on this aspect because if she is going to flee, we do not know where she's going to, so the court must rather look at is there a possibility or a likelihood that she may flee. The nature and the gravity of the charge, or the charges, which the applicant is to be tried for. The applicant is facing charges which are of a serious nature, and it is evident by the fact that it will be tried in the High Court. It relates to elements of dishonesty, but it does not include elements of violence. The next factor under subsection G is the strength of the state's case against the accused and the incentive that she may have in consequence to have an attempt to evade trial. There is sufficient evidence to charge her. As already said, there is an indictment, and if the DPP decided to charge her, they must be satisfied that there is sufficient evidence to charge her in the High Court. The information that was revealed in the bail application was that the applicant was initially approached with a view of interviewing her in order to convince her to become a state witness, or to consider her as a state witness at least. And then she at one stage cooperated, and after that she did not further cooperate. And this was clear to the court as well that it was to the dissatisfaction of the investigating team. A decision was taken to investigate further, and she was then charged. The charges flows from her involvement and actions that was taken by her while she was the personal assistant of the previous premier, Magashule'S. And he will be standing trial with her on fraud, corruption, and money laundering charges in the High Court, together with a number of other accused. Under subsection H, the nature and gravity of the punishment which is likely to be imposed should the accused be convicted of the charges against her. If she is convicted, we all know that there's a minimum sentence applicable. She will most probably be sentenced to a period of direct imprisonment if convicted. The next factor, I'm going to take the last two together for this purpose, the binding effect and enforceability of bail conditions which may be imposed and the ease in which such conditions could be breached, and any other factor which in the opinion of the court should be taken into account. I take into account that it is possible to fix bail conditions which will limit the possibility of the applicant fleeing from the country and even to limit the movements of the applicant from within the Free State province. I do not find any evidence, if I say I find any evidence in this affidavit of the state to support the claim of the state that the applicant is a flight risk and that there is a likelihood that she will not stand trial. She was a resident and a student in the United States at all times. There is no evidence that it was difficult to get hold of her when she was needed. It appears that there was a regular communication between her and the state and her previous legal representative and the state to a point, and then the legal process with regard to her came to a standstill for quite a while. At one stage, her address was apparently not known to the authorities in the United States, but she was also located in order to start the extradition proceedings. The applicant indicated that she was at all times still a student at the university attending classes. I do not have any evidence from the state that there was an instruction issued that she must inform the investigating officer of any change of residential address if she does that. So in the absence of her being charged of an offence, she had freedom of movement. It's important to remember that there must not only be a suspicion of a flight risk or a fear of a flight risk, but there must be a likelihood that she's a flight risk and that she will not stand trial. This likelihood must be based on evidence. The court must also take into account subsection 9 before coming to a final conclusion, and that is reading as follows: in considering the question in subsection 4, the court shall decide the matter by weighing the interest of justice against the right of the accused to his personal freedom, and in particular the prejudice he or she is likely to suffer if he or she were to be detained in custody, taking into account where applicable the following factors. The first one is the period for which the accused have already been in custody since her arrest. We've calculated approximately 4 months. Most of that was in the United States. She started her bail application on her first appearance in court. The accused, the probable period of detention until the disposal of the conclusion of the trial, if she is not released on bail. If I look at the charges and the number of the accused, the amounts that's involved, it is safe to conclude that this will be a lengthy, drawn-out trial, which could take several months or even years to finalize. The next factor, the reason for any delay in the disposal or conclusion of the trial and any fault on the part of the accused with regard to such a delay. It appears from the replying affidavit that the applicant is not the cause of the delay for the trial, and it is supported by the arguments presented by the state as well. The delays were caused by a co-accused bringing different applications in the courts in South Africa, and this fits in with the version of the applicant that there was a long period in which she was not contacted regarding her being charged, and that was the period in which she apparently changed her address. Any financial loss that she may suffer, her life will come to a standstill if she's detained in custody until this matter is finalized. Now, she's also being supported by a legal team, so there's also nothing preventing them from consulting with her and preparing for trial, so it is not anything that can count against the state. Any other factor is the fact that the applicant made use of all the legal resources available to her while she was still in the United States and also now in South Africa in order to defend herself. This is not a factor that can be held against her. She has a constitutional right to have access to the law and to the legal proceedings, and it may not count against that or if she relies on her rights as a citizen. And it does not mean, and the court cannot come to the conclusion that as a result she's a flight risk. The defense offered an explanation why they abandoned her bail application in the United States, indicating that there were false allegations made against her about her connections in other countries. This was not disputed by the state, although the state was given the opportunity to do so. After all of this, I am indeed satisfied that the defense proved to the court on a balance of probability that it is in the interest of justice to grant bail to the applicant, so bail will be granted. So the only aspect that we are now going to deal with is the amount of bail and possible bail conditions. So can I just hear from the state the bail conditions that you would like to be imposed on the applicant?
that the applicant not travel beyond the magisterial district of Limpopo, that she reports to the Park Road police station daily between 8 and 10. Very good, thank you.
8 to 10,
Excuse me.
you said between the time 8 o'clock in the morning until 10 at night, or 10 in the morning.
10 in the morning.
Can
It can
I?
be amended, it's not cast in stone.
No, it's fine. I took it. Marela, can you please address me firstly on the amount of bail?
Your Worship, we, in our replying affidavit, made examples to instances where the state has understood the present financial circumstances of an accused, quite apart from their usual financial circumstances, and using the Pistorius case, where he was granted 10,000 rand bail, owing to the fact that she is still currently unemployed, but mostly due to the fact that most of her belongings are still in the United States, and so she just simply does not have any financial means for anything at this point. And the amount of bail that we had suggested previously, we submit that that should be the amount of bail that it is set at. Yes, that is what we submit here, Your Worship. She is presently just unemployed, no connections or means to support herself whatsoever, other than from her family, which we do not understand is a wealthy family. They do what they can as middle class families. So that is, I think, the amount that is appropriate in the present circumstances, Your Worship.
The bail conditions?
Your Worship, we stated in our founding papers that the applicant hails from Bloemfontein and Parijs. We were emphatic in that. In fact, most of the family members in the courtroom currently today and in the bail proceedings have all traveled from Parijs, where her deceased mother and deceased father were from. We think it would be rather punitive to ask her not to visit Parijs, particularly now that she is back in South Africa, and would beg the court's leave to have the jurisdiction rather be the Free State, or rather up until Parijs and no further, rather than simply Bloemfontein. But we are indebted to the court and we are subject to the court's discretion.
And the reporting conditions?
Would that be daily? The advocate for the state did not mention whether that would be daily. He simply mentioned the time.
No, you said daily between 8
Daily.
and 10.
We think that is rather stringent, Your Worship, given particularly that this is a Schedule 5 offence. We think that a daily reporting schedule is more suitable for a Schedule 6 offence. We would be more amenable to a weekly or a reporting period of every few days. But daily is rather stringent, particularly considering she will be living with people who are working every day, and we do not know how she will be able to get from Eitzig to the police station every single day, and perhaps leeway could be afforded to her in that regard.
Park Road Police Station is close to us,
Close to us.
correct?
As it pleases.
I'm going to now continue with the amount of bail and the bail conditions. Once a court decided to grant bail, the court must now decide whether the bail is affordable and take into account various factors. The accused is able to raise an amount of 2,500 rand bail, and therefore the court is granting bail in the amount of 2,000 rand bail, 2,500 rand bail. Bail conditions are that the accused will appear in court on every postponement date, 8:30 in the morning. She shall stay present in court until her name is called. The accused may not leave the boundaries of Bloemfontein without the consent of the investigating officer. So you have to contact the investigating officer if you want to go and visit your family in Paris, and just inform him of that and just keep him up to date with your movements to wherever you go. So you have to inform, and the investigating officer must give you consent. The accused shall report to the Park Road police station every Monday and every Friday. So it's twice a week, every Monday and every Friday, between the hours of 8 o'clock in the morning and 5 o'clock in the evening. Every Monday and Friday, anytime between 8 o'clock and 5 o'clock in the afternoon. If you do not comply with any of these conditions, there will be various options available. If you do not come to court, a warrant of arrest will be authorized for your arrest. Your bail will be provisionally forfeited to the state. If you do not return after 14 days and your bail is finally forfeited to the state, you will be kept in custody. And that will then be until the matter is finalized. The other consequence of not complying with bail conditions is also that the state may bring an application for your release on bail to be withdrawn. And there are certain grounds upon which they can do that. That will then be an application in court to have your bail withdrawn and for you to be kept in custody. Do you understand the bail conditions?
Yes, I do.
Thank you. Nice.
Your Worship, I need to arrange a date with the High Court for a pre-trial for this accused. So I'd like to ask just for a postponement until tomorrow so I can just contact the judge's office of the judge president so that we can get a date when she can appear in the High Court for a pre-trial.
Defense?
Could I just get clarity on that, Your Worship, postponement of, you would like a postponement of these proceedings?
Yeah, just until tomorrow to get a High Court date.
Um, The suggestion from my attorneys, Your Worship, is that since it's still 3 o'clock and we still need to deal with the issues of bail, would it not be possible for Advocate Nation to make his arrangements and then inform the court thusly instead of one more night in custody for Ms. Cholota? However, we are indebted to the court and will be under the court's direction.
Yeah, she won't be in custody.
I see.
Yeah,
That
no,
is-
she pays her bail and she's out.
And do we still need to return?
I know that you're not from here. You're not local, so I don't
But
know.
we could stay if need be, Your Worship.
It is just to transfer the matter to the High Court. So it's just a formality, a transfer.
Yes, we are not opposed to that, Your Worship. We agree to that.
Thank you.
As a court, please.
So the matter is then postponed until tomorrow, which is the 16th of August. You have to be back at court at 8:30 tomorrow morning at this court, and that is just for a matter to be transferred to the High Court. If you pay your bail, you will be released immediately, and you have to return again tomorrow morning, 8:30 in the morning. Thank you. The court's adjourned. Have you got muscles? Have you got muscles?